Good morning to all of you. Today we are going to discuss the topic Novus Actus Interveins. Previously I told you in Rylands versus Fletcher case where strict liability is applicable according to Justice Blackburn. But if you are able to put the case in one of the defenses like act of third party, yes, it will be allowed and you need not pay compensation. You all well know that in the strict liability, normally the liability cannot be fixed on anybody because nobody will be found negligent. But still, because the damage was heavy, then actually the defendant has to pay the compensation. But he is able to prove that it is done due to act of third party or complainant complainant or plaintiff's default and also vis major or act of God or like that unexpected event, all these things you can go for defense, right? So this part, third act of third party, it is called in the legal concept as Novus Actus Interveins. That means a new act intervening. Suppose normally we will file a case against the defendant stating that he has not acted. So if the defendant says, Your Honor, I wanted to act in a positive way, but due to the act of the third party, I could not perform it, therefore this legal injury was done, then you will be absolved of the compensation. Then if you are able to prove it, you need not pay the compensation, but it is very, very difficult to prove the act of third party. So please remember, the defendant is not liable for the damage done to the plaintiff if the chain of causation between the defendant's act and the damage to the plaintiff is broken by the intervention of a third party. This is clearly stated here. So please remember, so Novus Actus Intervenes means intervention of a human activity in between the defendant's act and its consequences, right? I will give you two examples, but of course both of them are negative examples where Novus Actus Intervenes could not be proved, right? So the first case law, Chaurasia and Co. They are bus owners. Chaurasia and Co. versus Srimati Pramila Rao, 1974. So why I am putting up this case is these things do happen even nowadays also in villages or where there is overflow of water from the creeks, right? So Chaurasia and Co. they are the fleet owners or they are running private buses. So on one day their driver took the bus. He wanted to cross a causeway, but due to the heavy flow of the water, he could not cross the causeway. He has to go up to certain distance, particular point, and he stopped it there because he wanted to go only after the velocity of the river or the flow recedes. Otherwise, it will be washed away. Definitely, he is afraid. Therefore, he kept it there itself. But one of the overactive passengers, he got down from the bus. So he raised his lungi, dhoti, then he straight away walked to the other side and the water was only up to knee deep. Not knee deep, of course, knee deep, let us say some lower level of water is there. So enraged by this or encouraged by this, the driver tried to drive further. But after going to certain distance, due to the velocity of water, the bus was skidded, it has gone to the other side, entire bus washed away, and the passengers, of course, some of the people who knew the swimming, they could survive, most of the people died. Now, the survivors or the dependents of the passengers, they filed a case against the driver as well as the owner, that is Chaurasia and Co. Now, the defendant, that is, of course, it is since it has come as appeal, now we are reading it as Chaurasia and Co. for Pramila Rao. Actually, Pramila Rao and others, they filed the case against Chaurasia that they are responsible or their driver was negligent due to which the passengers died. The defense put up by Chaurasia and Co. is that actually the act of third party, Novus Actus Intervenes. That means he wanted to go to the other side, but due to the heavy flow of water or heavy velocity of water, this accident took place and they are not liable to pay the compensation. But the court did not agree because 40 to 50 members' lives are in the hands of the so-called driver. He has to take more precautions. He should not act negligently. He should take precautions. Let him wait for some more time. What is there? The water would have tilted there. If he's sitting at the water, he would have waited. Without waiting and taking a chance, of course, the passengers may be overactive or they may be over smart also, but you cannot take them as examples. You should use your brain. You should be careful. Since he is a negligent, it cannot come under the Novus, Actus, Interveins, and they have to pay compensation. This is the decision given by the court. Another case, that is Poppal Sitaramaya versus Superintendent Sub-Jail Bapatla, 2002. Actually, Sitaramaya's son, Mr. Anjibabu, he committed suicide while in jail itself. So, actually, the case was built up against, actually, this man was arrested in a case of dowry harassment. 498 and 306 IPC he was arrested. So, after going to jail, it is alleged that the relatives of that woman, his wife, they came and took the interview, and at that time they threatened him as to why he is still alive. If he comes out, they will kill him, better to die like that. So, he could not withstand the harsh words of those people, and maybe due to that, or in a fit of a moment, he committed suicide. They were fixed as responsible under 306. But they said it is not the act of our, it is the act of third party. Who is the third party? They say that. So the relatives came, the relatives of Anjibabu, they came and they threatened him as to who are you, when your family, you are the only person to go to jail. Why the hell? Better you, why don't you die? All this nonsensical fellow. So basing on that, he committed suicide. Of course, the court did not agree that these are it is not act of third party. So the relatives, of course, the case ended in acquittal because of there is no proper evidence, and the prosecution could not prove the case beyond all reasonable doubt. Anyway, this is also negative example, right? So please read these cases, and I'm sure it may come as a small question. So if you can write a page answer, it will be sufficient. I hope you have understood well. Thank you very much.